Yes. Hey, let's go ahead and get started. Thanks for being here. Thanks for being here. My name is Bill Keffer, and I'm here on the faculty at the law school and in charge of our energy law program, which includes this lecture series, the Energy Law Lecture Series. Many of you have attended these in the past. If you're a first year, maybe it's your first one to attend because this is the first one of the fall semester. So let me welcome you, but also welcome the folks who are participating and attending via Zoom, and remind those of you who are watching by Zoom or who might be here in the auditorium, if you are wanting CLE credit from attending this event, just stay tuned at the end of the lecture because there'll be a QR code that is put up on the screen, and you can use your phone to get the QR code, and that'll automatically register the fact that you were here with the State Bar of Texas. Okay. Also, just as a quick reminder to my students, if you are here in person in the auditorium, come down here and sign in on the attendance sheet, which is down front. Don't make the mistake of signing the CLE sheet outside the auditorium because I won't see that. Come down here and sign my attendance sheet to make sure that you were here to get credit. Okay. Let me tell you about the two remaining events that we have this fall in the lecture series. The next one will be on Monday, October 4th, and it'll be Krista Castaneda, who's a lawyer from Dallas, who happened to represent Boone Pickens in his last jury trial that happened out in West Texas in Pecos. And she wrote a book on it and is going to come talk about her experience representing Boone Pickens. So that'll be pretty entertaining. And then we will wrap up the fall semester lecture series on November 4th, Monday, November 4th, with a fellow named Doug Robison. Doug is a former oil and gas lawyer from the Permian Basin who thought he had retired, but has re-entered the private sector as CEO of a company called Natura Resources. And they're behind the effort at Abilene Christian University with a new nuclear program that the Nuclear Regulatory Commission just issued a permit to them to build this new reactor on campus. So he's going to come talk about the advent, this new sort of age of nuclear energy and the new technology that they're using, and sort of this opportunity to now try to pursue adding more nuclear energy to the lineup of sources of energy for our electricity grid and other sources. So be sure and mark your calendars for October 14th and November 4th for those events. And I would also invite you to look at the website that is ostensibly for our Journal of the Energy Law Practitioner, but it also serves as the portal for the Energy Law program at the law school. It's jelpttu.org. So jelpttu.org. You'll find a whole lot of information there about the journal, past issues, other things that are going on at the law school through the Energy Law program, but it also includes all of the previous speakers in the Energy Law lecture series that we've had here on campus going back to 2014 when we started it. So it's a very long list of really neat speakers who have been here, and you can get, for those of you who are practicing lawyers, can get 1 hour CLE credit from watching those as well. But even if you aren't seeking CLE credit, they're really interesting speakers, really interesting topics, and you've got the whole menu of everybody that's ever been here. And of course, this fall we'll be adding those lectures as well. So let me introduce today's speaker, and it's just a great honor, but also a lot of fun to have him here with us today. Craig Enoch, who is a former justice on the Texas Supreme Court and is only the second former justice that we've had here speak in the lecture series. And you might notice in the audience that our other guest speaker, who's former justice of the Supreme Court, is also the only Texas Tech law alum who's ever been on the Texas Supreme Court, Phil Johnson. So Phil, thanks very much for being here with us today. I always make the challenge to my students, hey, Phil Johnson's the only one from Tech law that's been on the Supreme Court. So that's a challenge to you guys to get busy, and let's have the next one elected to the Supreme Court in the future. But Craig Enoch's here with us. Craig started, practicing in Dallas and was elected to the state district court in Dallas County. And I'll just tell you a quick story on Craig. That was I had just graduated from law school, and I had my first motion, assignment, go down to a hearing and argue a motion. I think it was a summary judgment motion, and it was in Craig's court. And of course, I didn't know, I went to UT, so I didn't know how to do anything. So I was showing up, at the courthouse, like, what do I do? Where do I go? How do I do this? And there was just all this mass, chaos outside the courtroom and all the courtrooms, because it was a motion day. And so there were a lot of lawyers there, and they were going through lots of different items. And mine came up to bat in Judge Enoch's court at the time. And I didn't know it. I was outside. I was going back and forth trying to listen, went back out in the hallway to talk to a client, and I wasn't inside when they called my case. And so then I went in there to say, okay, I'm ready. And they'd moved on to something else. And I was like, oh, hold it. He missed me. No, he already went past me. So I went up there and got his attention, and he looked at me like judges look at you when you screw up like that. And he gave me this very stern look, like, I'm not sure I'm going to give you a second chance. You lost the motion. I granted the summary judgment to your opponent. And I was like, please don't make me go back to my boss, with that kind of story. So he said, okay, just pay attention in the future. So I know you don't remember that, but that was like my first, dive into the deep end of the pool. So thank you for not making it a horrible story. All right. Well, he's going to talk about, I think the name of his the lecture, the way he sent it to me, was Oil and Gas, a Dead Subject, but Don't Tell It That. He's got some great stories. He's going to come up here and sort of share some things with you from his experience. Like I said, he served on the Supreme Court from 93 to 2003. He's now a founding member of his current firm, Enoch Keever in Austin. They do a lot of practice in Austin with government agencies, before government agencies, and with the legislature, and basically helping clients navigate that whole business down there. He's certified in civil trial law. He's a member of the Texas Bar College. I mean, just bottom line is very smart guy, very successful guy, but also just a really great person. And I'm just so thrilled he's here with us today. Help me welcome Craig Enoch.
Is it on, or can you hear? Oh, I got it. I know where that button is. I can do it. It's an honor to be here. Now I feel untethered. Once Bill told a story about me, so now I can tell a story. As Bill said, he had graduated from law school and he came to his first motion. What he didn't tell you is he probably caught me when I was trying to figure out what I was supposed to do as a judge. And I've always referred to some of my most favorite people as being they were baby judges they were baby lawyers when I was a baby judge. And we've sort of grown up together. I've had these baby lawyers train me while being a judge on the old object of setting aside bias and prejudice and being fair. And I've felt like I've had the opportunity to relieve the baby lawyers of their nervousness. It's not, once you come in, it's not everybody's against you. There are people there who understand you need to get experience, you need to come forward, and are fair in treating the lawyers all together. So Bill and I have known each other for a long time, and we've known each other as professionals for a long time. I wanted to say, I've read up about the energy program before I came here. I'm very excited about the energy program that Bill is directing here. I'd encourage you to think about it. I was being facetious when I said the title of my talk would be Oil and Gas, a Dead Subject, but Don't Tell It That. Actually, I and my wife were both told that at my law school, that oil and gas was a dead subject and not to take it. Well, it turned out to be 1/5 of my bar exam. And fortunately, to BRI, I actually passed the exam. But as you can tell, oil and gas is not a dead subject. It is far from a dead subject. One of the things that I saw about your program is the first year law or oil and gas 1, you get to take a field trip to go see an active drilling well. I encourage you to do that. When I stepped off the bench back in 2003 and went back into practice of law, people thought the only thing I could do was argue cases. So naturally, they all lined me up to go argue cases. And I got sent to Texarkana to argue an oil and gas case. And it had to do with Union Pacific has these big right-of-ways, and they have an easement for the right-of-way. Well, Union Pacific was claiming it had the right to the mineral rights all the way down below its easement. Well, of course, the landowners were saying, no, we gave you an easement to run your railroad. We didn't give you an easement for the minerals. So the issue was the Texarkana Court was being asked to decide who owned the mineral rights under that easement to the middle of the track. And I, of course, were arguing that the landowners had those mineral rights, and the big bad railroad company, which we're going to talk about in a little bit, was arguing otherwise. On the way back, the lawyer had asked me to do it. His brother was a wildcatter drilling a well in Tyler, Texas. So he said, you want to stop by and see what he's doing? I said, sure. I've never seen a well being drilled. You know, you see movies and that sort of thing. So I don't know. So we go to this oil well and they are drilling. I guess it hadn't come in yet. They're actually, he was a driller and they're drilling like mad. And oh, wow. And my friend Mark said, let's go up in the doghouse. You know what a doghouse is? Doghouse is this structure that's on the drilling rig. Now, I have no idea why it's there because it's not going to protect you from anything, but it is this structure. It's a little house. We go up there, and now they're going to pull the bit up to add another length of pipe. So there's some sort, you have to pull it up, disconnect, and then you plug in a pipe, you drill it down, and then you put another pipe on top. That's kind of how you're connecting these things. And they're pulling it up, and wow, this is really exciting. But something in my mind told me the doghouse is here for a reason. I couldn't quite figure it out, but I stepped back into the doorway of the doghouse as this drilling rig is pulling this stuff up, and the workers around there, I was surprised he had all 10 fingers, thumbs, and he still had all of his hands there, but it was amazing what he did. He's wrapping this thing out. It's coming up and it's coming up, and all of a sudden I see some fluid coming up through the pipe. I kind of stepped back and I've got my head out the door. Mark had no clue what was happening. He was standing full on in the door. And when that bit came out, yes, from here down, his suit was covered in mud and rocks and sand, and I didn't get a bit of it. And so we drove all the way back to Dallas with him just dripping in his suit in the car. So if you have an opportunity to go see a oil well being drilled, there's a purpose for that doghouse when you get up there. But I tell you, I'm really excited about the program. It's some experiences that I've had, and I hope you get that opportunity. I'm also happy that my son's here with me. I'm going to get to my story in a little bit, but my son, who's a graduate of Texas Tech, employed in Dallas, had his real estate investment degree from here. I'm glad he's here. We brought him up to look at the campus, or rather, we got him several times, but his mother and my wife brought him up to look at Tech, and he said, I really want to go here. And Kay goes, well, Gates, why do you want to go to Tech? And they're right out in the middle of the campus, the undergraduate campus. He goes, but Mom, just look. And he had fallen in love with the campus. He thought it was a beautiful campus, as I do. And so the rest, as they say, is history. Okay. Now, what did I want to come talk to you about? You will see what the subject I want to talk to you about is an old subject. But as I got ready to talk about it, I found out the story had been repeated as late as June of 2024. This summer, a publication repeated this old story that I wanted to talk about. So I decided it's still current. So you might be interested in it. You'll drive down the street and you'll see stores that say in business since, pick the date, 1850, 2009, whatever it say. Well, there was a headline in 2016 in a newspaper that said an oil company that's been trying to go out of business since 1888. And it had to do with a legendary story called Certificate 390. What was Certificate 390? It was one of many certificates that represented shares of the Texas Pacific Land Trust. Has anybody here heard of the Texas Pacific Land Trust? Okay, see, you all were born after all the events transpired there, but it's a major owner of oil and gas plays in Texas. I'll get to that in a minute, but let me describe it to you. The Texas Pacific land shares, their certificates, started being traded on the New York Stock Exchange in 1927. In 2021, Texas Pacific reorganized from an LLC to a C Corp. That's your usual corporation that you understand with shareholders and board of directors and CEOs. 2 months ago, let's see. Oh, as of this past Friday, Texas Pacific Land Trust had 23 million shares outstanding at a market price of $887 per share, which is, well, one of my little calculators, it didn't have enough zeros, but I believe it's more than $2 billion is the capital of Texas Pacific Land Trust. As I mentioned, we see all this publicity. 2 months ago, the legend of this Certificate 390, which is shares in Texas Pacific Land Trust, was again recounted, and in time it was a market newsletter, Insider Trading. But the story begins in 1871. Yet I want to give you a little background first. There was a Civil War Union general, Don Carlos Buell. Has anybody ever heard of Don Carlos Buell? Well, not surprising. A war historian, Alan Nevins, synopsized Buell's Union Civil War history thus. General Buell was a brave and industrious master of logistics, but was too cautious and too rigid to meet the great challenges he faced in 1862. Buell was relieved of field command in late 1862 and made no more significant military contributions until his resignation in 1864. No wonder you haven't heard much about General Buell, except he understood logistics. One of the reasons he was always slow and late getting to his assignments is because he was always concerned about the rail transportation. He learned the value of rail transportation and supplying the front lines. After his service, he was influential in convincing the country that they needed a southern transcontinental route. And so he was influencing Congress to support rail from the East Coast to the West Coast through the South, so it wouldn't be disrupted by the winter weather. The Texas Pacific Railroad was envisioned as part of that system, completing the Texas segment from Texarkana down to El Paso, or maybe from your point, it'll be Texarkana down to El Paso that way. So they got the Texas legislature. It adopted a statute that would allow some of the Texas lands, in fact, a large swath of land owned by Texas, a nascent state, if you will, to be hypothecated. Hypothecated, that's a fancy word. You're in law school, you ought to learn that word. It has to do, you're taking the land and you're pledging it for some public obligation. And so what they did is they pledged this land to support government bond offerings to raise money for construction of this railroad that will go from Texarkana down to El Paso. There are some characters that I want to talk about briefly. Blake Brothers. Blake Brothers Company was engaged in stock brokerage business in Boston and New York. It represented individuals who purchased Texas bonds securitized by Texas land. It ultimately represented individuals who purchased interests in the Texas Pacific Land Trust. Those interests were reflected by certificates 386, 387, 388, 389, and 390. Another participant, Decker Howell and Company. Decker Howell and Company was a private bank located in New York. Now, this was all happening in the late 1800s. You don't have a federal banking system. They had a private bank. A private bank is only as good as its investors and its well-heeled investors and its own investments. It failed during the 1890s. We had a big recession. Well, everybody talks about the gay 90s, but we had a big recession in the 1890s, and the Decker Howell Company failed. The New York Times said as of July 14, 1897, Decker had gone completely out of business. Now, another character, Captain Joseph Raphael J.R. de la Mare. As reported in the Journal of International Bond and Share Society, I can't even pronounce this word, Scripophilie, you don't know what that is? Scripophilie? It's an organization that collects collectible shares and stock certificates. And it's a big publication for investors. It came out and it said about J.R. de la Mare, he was a brashly adventurous son of an Amsterdam banker. At the age of 7 in 1850, just after his dad died, he stowed away and went to sea for 20 years at 7. Think about that. He actually rose to the rank of captain in the merchant marine. He sailed the seas, as I said, more than 20 years. He transitioned away from of seafaring after the Civil War and settled in Martha's Vineyard as a scavenger. And he'd scavenge the sunken ships. It was Simpofoli kind of Riley mentions that after the Civil War, there were lots of things to salvage out of the bottom of the river or the bottom of the coast. He did that for several years until one time when he was diving, checking out the next salvage operation, he got trapped underwater for 36 hours. He said, well, okay, that's enough. I'm leaving that. He goes to West Africa and then buys a steamboat. Now he's going to be transporting goods up and down a river in West Africa. He's a serial entrepreneur. And then he has problems with his employees getting sick and dying from malaria. And so he just sells that out and he comes back to the United States. And now he decides to follow the fortune hunters to Leadville, Colorado, and learn mining. In fact, he went back to school to learn mining when he went back over there. And he developed a process for separating gold from other ore. And so became a very successful mining magnate. My final person I want to talk about is H.B. Parsons. H.B. Parsons, that said Esquire. Now, today, if you see Esquire by lawyers who are from out of state, that's kind of a formal designation rather than a JD. They'll say Esquire, and then you'll know they're a lawyer or something. It's not clear that H.B. Parsons Esquire was a lawyer. What was clear, he was cashier of Wells Fargo Bank, New York. Cashier at the time, that would have been president of that bank. It looks as if, and actually turned out to be, that Parsons not only was the president of the bank, he was the personal financial advisor of J.R. DeLamar. I don't know if banks would let the bank president be a financial advisor to one of their big clients, but today, but that's what he did. Now I want to go back to the story. Beginning at Marshall, Texas, the Texas Pacific Railroad reached Texarkana, going back to the east, and then headed west toward El Paso. By 1881, rather than go on to El Paso, it connected to the Southern Pacific line in Sierra Blanco, Texas, which is just short of El Paso, way out in West Texas. And a sidebar comment, Southern Pacific was part of the group that met in the Transcontinental Railway and the Gold Spike and all that. Southern Pacific was one of those that did the meeting. Union Pacific was coming from the other way. Well, Southern Pacific was moving like mad. And so it got past El Paso before Texas Pacific got there. And that's why they connected up at Sierra Blanca. They connected up where they showed up out there in West Texas. In 1879, a couple of years before that, a robber baron by the name of Jay Gould invested in the Texas and Pacific Railroad. He's called robber baron. I had to look up robber baron to find out what it was. Apparently in the late 1800s, robber barons were designated as all the big rich money people who obviously couldn't have gotten rich without being double dealers and, playing dirty and not playing by the rules. And maybe that's true, but that's why we call him a robber baron. I do have a story about Jay Gould, by the way, but he invested in the railroad. The railroad eventually laid 1,000 miles of track. It Texarkana down to Sierra Blanca. So it satisfied the obligation for the land to be turned to, for the land to now securitize the bonds that had been sold to finance railroads. So now the land is backing up the obligations to the bonds. By the early 1880s, however, now they finished in 1881, so shortly thereafter, the railroad's financial stability collapsed. Turns out, going east in East Texas, it's rainy, wet, and swampy. And going west to El Paso, it's harsh, heavy winds, blowing sand, neither is a good environment for maintaining rails and the substrate for the rails. It found out that the cost of maintenance of the railroad was fast exceeding the income in a sparsely populated area. And so the railroad declared bankruptcy in 1885. At that time, the railroad's assets were sold off, eventually being acquired by Jay Gould and then by the Missouri Pacific. Maybe that's one of the maneuvers that solidified his reputation as a robber baron. He was an investor in Texas, but somehow he figured out how to buy the assets cheap and put them in Missouri Pacific. Which brings me to the story of Jefferson, Texas. Now, Jefferson, Texas is north of Marshall, Texas. It's out in East Texas. Let's see, where you all? Yes, that would be East Texas to you all. And Jefferson became famous because during the Civil War, it made uniforms and ammunition. It took down all of its wrought iron, all of its iron fences. It was an ornate Victorian kind of town. Took all of those down, melted them down for ammunition for the Confederacy. They took all their cotton crops, they turned them into uniforms. They outfitted an entire army in the Confederacy. This was Jefferson. It was a big city, and it was actually, it had access to Galveston, the port in Galveston, because the river, the Red River going through there was navigable. It was a branch of the Red River. It was navigable over the Sabine south out into the Gulf. Jay Gould, Missouri Pacific, in 1890 visits Jefferson and says, I want the city to support me bringing the rail through here. You need to have a rail transportation from Jefferson. The Jefferson City Council looked at their river, looked at their trade. They said, we don't need to help invest in a railroad. We don't need to give you land for a railroad. We're not going to do it. Jay Gould notoriously signed the logbook in the Excelsior Hotel. I will live to see the day grass grows in the streets in Jefferson, Texas. Now remember General Buell? General Buell was interested in rail coming through, but he was also still very active in Washington, D.C. There is a conspiracy theory thought that because Jay Gould was turned down with the idea that they had plenty of river traffic, is the reason the Army Corps of Engineers showed up a couple of years later and blew up the natural dam at the joint of the Red River, and Jefferson became a landlocked city almost immediately thereafter, and the city died. Now, I'm just saying that's a conspiracy theory, but at any rate, you can go to the Excelsior Hotel in Jefferson, you can look at the logbook where he signed in, and Jay Gould said, I will live to see the day that grass grows in the streets. Well, now they've restored it. Jefferson's a great town. It's a great place to visit if you ever want to go. Enough of the story. I haven't finished my certificate 390. Oh, yeah, I remember. That's what I was going to talk to you about. The Texas Pacific Land Trust. Through the bankruptcy, the Texas land was placed in trust for the bondholders. And each, according to their interests, were issued certificates numbered consecutively, with each certificate reflecting 100 shares in the trust. You all are just most of you all are just now here, so you're going to learn about bankruptcy a little bit later. But, bankruptcy is, I call them the whips and chains boys. They can do anything they want to try and resolve the debt, get debtors paid, maybe get them back into business, or maybe just got to take them out of business, liquidate them. But the bankruptcy court has a lot of discretion to do those things. One of the things that the bankruptcy court was figuring out is we've got all this land that backed up the bonds. It's scrub land. It's worthless. There's not much out there except some lizards, which I guess are endangered nowadays. And so he said, okay, we're going to take all that land and we're going to give it to the bondholders in satisfaction of the railroad's obligation to bondholders. I don't know if it made up the difference. It probably didn't, what the investment was, but that's how they resolved that part of the issue, to take care of the bondholders with the land. So they got the land. So they had to, what do you do with the land? You got to create a trust. Nobody wanted to buy this scrub land, this wasteland out there. So So they just created a trust. They called in the bonds and they issued the certificates. As I said, nobody really considered this land worth anything, but in 1920, a major event changed the trustees' responsibilities virtually overnight. Texas Pacific Abrams, number one, what a cute name, the first producing oil well in the Permian Basin. Within a few years, the basin had its first pipeline. Texas Pacific Land Trust, was a major owner of the minerals in the Permian Basin. Much of this story, you can actually read much of this story in your textbooks here. Martin versus United States Trust Company is actually a published opinion out of the Dallas Court of Appeals, 1985. The court was recounting the facts in the case, but I'm paraphrasing, so I'm not going to quote what they were saying. But they mentioned in 1885, Texas Pacific Railway went into receivership, bankruptcy, and only a few years after Texas had granted it millions of acres of Texas land to pay back the bondholders. In 1887, the plan of reorganization was approved, creating a trust known as the Texas Pacific Land Trust. The millions of acres of land were conveyed to the trust that in turn issued its certificates, bearing a par value of $100 each in exchange for original certificates of deposit of the railroad. Remember Blake Brothers? Blake Brothers, in 1888, Blake Brothers possessed bonds in an aggregate amount of about $50,000. It was registered to 13 different owners. It presented those bonds to the trust, endorsed in blank. Anybody know what endorsed in blank means? Whoever possesses that certificate or that bond is the owner. Endorsed in blank. It could have been anybody, but whoever actually holds it becomes the owner of that. So they submitted it on behalf of 13, endorsed in blank. The trustees said that's fine. They issued new certificates to them, 5 in particular, which were the 386 through 390 certificates. And they were issued in the name of Blake Brothers. So they issued it to the Blake Brothers being trustees for the other 13. They got these certificates in the name of their others. 4 of these 5 new certificates were eventually endorsed in blank by Blake Brothers, and between 1893 and 1902 were tendered to the trust for transfer to some other owner. The question arose, well, where's certificate 390? And this is when it became a mystery. Through oil revenue, the oil revenue was trickling into the trust. The trust only began paying dividends in 1936. By that time, Blake Brothers was totally out of business, had dissolved. From 36 to 48, the trust paid dividends on all 5 certificates, including 390, to the successors of Blake Brothers. When you have a partnership and it dissolves, whoever was the partnership partners at the time, they get whatever revenue ultimately comes in. So the trust said, well, Blake Brothers is dissolved. We're just going to pay it to all. We assume they had 390. We don't know where it is. And they started paying it to Blake Brothers. But in 1952, the Blake Brothers were unsuccessful in getting the trust to issue a replacement certificate 390. The trust said, wait a minute, oh, where's 390? And now it's worth a lot of money. So they decide they're going to file in Texas, where the money is being held in a bank, because the trust actually has its headquarters in Dallas. And so they say, we're going to deposit in the bank, and we're all going to have a lawsuit to determine if we should pay the money to Blake Brothers or determine who owns this certificate 390. They sued the trustees in New York for the replacement of 390. That court turned them down, said you can't prove that you're the owner. They came to Texas in 1961 and filed the lawsuit again. And in particular, Texas this time joined to escheat. That's another word for you. You can learn about escheat. It's when somebody never claims their estate, then Texas can make a claim to that estate and take it for the state. It's called this cheat, and there's lots of protections on it. But Texas was going to try and exercise that since they had failed to establish, Blake Brothers had failed to establish their ownership. Nobody seems to have it. We don't know where it went. Texas said, well, we might as well put our hand into this. And so they filed an escheat action in Texas state court. My guess, yeah. What certificate? Well, in 61. So what happens there? In 61, they lose in the New York court. And so they come to Texas. They tried again. The successors then sought a determination in the Texas court. You'll find a case out of Texarkana. I don't know how it got there. It was a Texas. It was Dallas trial court. But in Texarkana, Davis versus Frazier in 1958. And you'll see a Texarkana opinion on it. In that case, the trial court had appointed a Mercantile National Bank. It became M Bank. It's now, I don't know, Bank of America, and we call it North Carolina Bank, no cash, no borrow bank. I don't remember what it became later, but it became the custodian of the proceeds of Certificate 390. A great old, I say old, he was a young lawyer. Just think about this. You ever get appointed as an ad litem for a bank account? It may be a great payoff, because one of the venerable old lawyers who I met when I was a baby judge was the ad litem who had been appointed 30 years earlier to be the ad litem for this custodian as a young lawyer. And he had literally grown up with the case. Robert Blumenthal was his name. And so, as I said, the state of Texas joined the lawsuit in Texas to escheat it. Perkinville hired Robert Blumenthal to be their lawyer, and Mark Martin was a guardian ad litem for all the people out there who have a potential interest in the certificate but don't know the certificate. And the names I'm mentioning to you are names you wouldn't be familiar with. But as a baby lawyer in Dallas, it was amazing to see these old lawyers sparring in court like teenagers. Their first opportunity to go back and really get in the trial of the thing. And they were really old, but it was a fun sort of case to watch them practice in. And Jack Howell was representing he was representing the trust at the time. And Aiken Gump, Strauss, Howard, and Feld. If you've ever heard of the Aiken Gump firm, I mean, the senior partner was still alive at that time. Okay. What happened? The trial judge, his name was Dallas Blankenship. I always thought that was a great name, Dallas Blankenship, for a judge in a Dallas district court, ordered the parties to write an article to basically make a public appeal to anybody who might know anything about Certificate 390. And it is said, there's no record of it, but it is said the article probably went around the world twice, from about 65 to about 79. And it did go internationally. It was published in international newspapers, and it came back around a second time. A little aside. Anybody watch The Music Man? Anybody see the movie The Music Man? Well, there's a few of you who have watched it. That was my dad's favorite movie. But in The Music Man, there's a song about, oh, ho, the Wells Fargo wagon is a-comin'. Oh, ho, the Wells Fargo wagon is a-comin'. Oh, ho, the Wells Fargo wagon is a-comin'. Wells Fargo had an express business. It had a New York bank. It had a San Francisco bank. And it ran express wagons from the East Coast to the West Coast. And so all the small towns, their haberdasheries, their little dry goods stores would get their goods across land from the Wells Fargo wagon. In 1905, Wells Fargo closed its New York bank. You remember Parsons? Parsons was a cashier of Wells Fargo in New York. Well, in 1905, Wells Fargo closed its New York bank. We didn't really have branch banking. Branch banking was not allowed. So they were operated independently, but under the same name. But they used the express as the way to connect the two banks. It shuts down, but the express part of the business stays open until 1919, when it gets shut down by World War I, when the federal government comes in and says, we can't have these express wagons in competition, we need to be much more efficient, as the government always says, by us making you all merge and become one express to do the express work across the country. So now Wells Fargo's express business is shut down. So they close entirely in 1919. Remember the articles going around the world. Well, in 1969, Wells Fargo San Francisco decides they want to capture all of this great history of Wells Fargo. Wells Fargo was established in 1852, I guess. And so if you go to San Francisco today, they've got a museum in the bottom floor of their headquarters building in downtown San Francisco. They decide they're going to go back and find all the history of Wells Fargo. When they closed down in 1919 because of World War I, they transferred all of their express assets to the reorganized combined express business, American Express. So in 69, while they're looking for the history of Wells Fargo, they reach out to American Express and say, American Express, do you have anything from the Wells Fargo days? Why, yes, we do. We'll sell it to you. So Wells Fargo bought all of the stuff left over. I think it said 4 million pounds of paperwork is what Wells Fargo bought, and moved it from the American Express offices warehouse to Denver, Colorado, to warehouse to store it. Okay, we got 4 million pounds of paperwork. What are we going to do with it? Well, they assigned a gentleman by the name of Edward Munger to go to Denver, spend some time, and catalog all the documents. Some of the reports later on will say a historian was, well, he was just an officer at Wells Fargo Bank, probably an archiver, probably one hired to help them capture, their Wells Fargo wagons. I mean, a lot of actual physical things as well as the paperwork. Goes to Denver, starts cataloging. He finishes the catalog, finishes his job. He's now back in San Francisco. A couple of years go by, and now he's retired. On a Sunday morning, he is back drinking coffee, reading the San Francisco Chronicle, and there is an article in the San Francisco Chronicle headlined, 2 million missing bond, Texas Pacific Land Trust bond number 390. I've seen that, he said. I know where certificate 390 is. He calls the president, and that afternoon, the president and he fly to Denver. They go to the warehouse, and he literally walks the president right up to the safe that he had cataloged, opened it up, and there was certificate 390 sitting on a shelf in the safe. Now, the mystery thickens. So he found the certificate, but there were 3 other documents with the certificate. There was a letter from a lawyer referencing the certificate. There was a promissory note from Decker, remember Decker? Decker, Hal? To J.R. Delamar. Remember J.R. Delamar? I mentioned that. And then a letter from this lawyer from a law firm in New York suggesting that the certificate had something to do with the note that was sitting in the safe that was made out to J.R. Delamar. The note was non-interest bearing. It was supposed to be payable within 4 months of when it was issued. And certificate 390 was a bearer certificate. It was blank in its endorsement. Well, that caused them to say, we need to investigate this further. Well, Parsons, remember Parsons? Parsons apparently had the habit of being a meticulous letter writer. And the letter was addressed to Parsons from this lawyer in New York. And Wells Fargo happened to know that Parsons' letters had been bound in 9 volumes currently at the Huntington Library in California. They go off to California and find the volumes of these letters. Everybody who participated in this transaction was dead by 1909. Everybody who knew anything about this transaction was dead by 1909. How did we have copies of Parsons' letters that he wrote to third parties? I mean, it probably doesn't even baffle you. You grew up smelling whatever, the mimeograph machine ink or something. How do you do? Parsons, being a meticulous letter writer and being a business confidant, used a letter press. You've seen pictures of these old presses. He'd write a line with his ink while it was still wet. He'd run the press down, make a duplicate through a piece of sheepskin, the real thin kind of paper, so it'd bleed through. Then he'd open it back up, or he'd write another line, and he'd press it down. 9 volumes of his correspondence in Huntington Library. In 1979, now Wells Fargo intervenes in the court where the state was trying to cheat, making a claim, well, we have possession of it. Remember, it's a bearer, so that's our possession. And now the state realizes their chance of this cheating is kind of going away. So the fight was left between the Decker heirs. Remember, their names in this letter talking about something about a debt. J.R. Delamar's heirs. Remember, there's something about the note was made out to him. And then Wells Fargo, because we have possession. You know, possession is 99% of law, right? So now the lawsuit begins. And they're trying the case in Dallas, Texas. You find letters that talk about the certificate is given to you to be the security behind my agreement to pay you $15,000. Now remember, this certificate at the time was worthless, really worthless. But Decker had said, I owe you $15,000. I'm late. Here's my certificate 390 of shares in this Texas Pacific Land Trust. And I promise to pay. Then another letter from this lawyer that they find in the Huntington Library from Decker's lawyer is going back and forth with Parsons. Well, I haven't been able to pay, hasn't been able to raise the money, but I'm working with him to try and get it paid. And then kind of the letters sort of stop. So the question becomes, its bearer, we know by the letters that it was intended to secure the payment of the note. And it appears, at least to a point, that the note had not been paid. And so what's going to be tried? So for 3 days, a jury sat in the jury box and heard the librarian from Huntington Library read one letter after another, after another, after another, to have the jury decide the question of fact. Was the security foreclosed on? Who has possession of it by J.R. Delamar, or was the debt paid and we just don't have a reflection of the debt paid? So Decker, his heirs, there were about 140 of them, would collect. Or as the state of New York might say, well, more than 6 years had gone by and they didn't foreclose on the certificates, so it would go back to the debtor anyway. Kind of 3 issues. The law question got decided. Texas law is going to apply because the certificate, if the trust is here, the certificate is in Colorado, there's no reason that New York would necessarily apply. And the judge wasn't sure that it was going to be different anyway. And the jury only got 2 questions when they got to the end. The 2 questions were this. Issue 1 asked the jury to determine whether the certificate was delivered as part payment of the note or as a pledge to secure payment of the note. That was the first question. The jury said that it was delivered as partial payment. Remember, the certificate is worthless. There was a $15,000 note. The certificate at best at the time was worth $700, maybe. Like $7 is 100 shares, and it was like $7 a share. So it was nearly worthless. So was it in partial payment of the note, or was it just a pledge to secure? The jury said, oh, no, it's partial payment. They just took it as partial payment, knowing the $15,000 wasn't going to be paid. The second question asked the jury to determine whether the certificate was delivered by Decker to Parsons on or before September 8th, 1896. That's the date on whether the New York law might require the security to be forfeited because it wasn't foreclosed on. And the jury came back and answered that it was delivered after that date. And so the New York law wasn't going to apply. A complicated case, only two issues, the jury answered. Now, the certificate at the time it was tried in 1982 was worth 4,000 shares of Texaco Oil Company. And that was roughly $5 million was in the account, determining who got the certificate. The worry of the trial judge, if Decker wins, that is, it was just to secure the debt and that it was never foreclosed on, had 140 errors. The whole case would start all over again, trying to find the 140 errors of Decker's interests. Or J. DeLamar might win. And if J. DeLamar won, he had a will. Columbia Medical School, Johns Hopkins Medical School, and he had a surviving daughter who was still alive. A lot of sweat and bullets came out of the judge's forehead, worried that the jury might say it goes back to Decker. But by golly, they decided for J.R. DeLamar. That was it. The case was over. It went up appeal, and it was affirmed in the Court of Appeals. And the rest of the story is, I was a baby judge when I tried that case. Thank you for letting me be here with you.
All right, well, thanks for being with us today. If you've got time, come down and introduce yourself to Judge Justice Enoch. And if you can come to my class at 2 o'clock, you're welcome to come to 106 and sit in on some more conversation. Thanks for being here.
Well, I think I
Great
kept,
story, man.
I think I kept
Had
our
just
attention.
enough time.
You did, man. You're a pin drop. Oh,